The current session of environmental law is on Water Prevention and Control of Pollution Act of 1974. When we talk about water pollution, it is currently is one of the considered as one of the major problems facing the humanity. And when we talk about our life, which has changed a lot, when we think about technological advancements that has happened everywhere, and in every sphere of life, and the country, like us, like India, has received and receives abundant amount of rain, but factors like increase in population is the main reason why there is scarcity of water still that we are faced with. And due to pollution and population increase, natural resources are being consumed more and more by many industries, and when many industry gets established to fulfill our demands, a large number of water bodies like lakes, river, reservoir, they get polluted due to the effluent released from factories, mills, tanneries, urban and rural sewage. So now water pollution adversely changes the quality of life because it disturbs the whole balance of ecosystem, and hence causes health hazards to human and animals also. And that's the water pollution. It occurs usually, mainly it occurs due to the use of pesticide fertilizers in agriculture, enrichment of water by nutrients, nutrients like, and nitrate, phosphates, and results in eutrophication of lakes, water bodies, and afterwards this results in excessive growth of depletion of dissolved oxygen in the lake, because it led to the growth of algae, and oil spills from oil tankers, and causes many kind of pollutions like many marine pollution. And all of this has adverse impact on water by polluting it, by reducing the quality and wholesomeness of water. And major sources, so that's the major source of water pollution essentially comes from the community waste, from the human settlement itself. And the Constitution of India, through the provisions of Article 47, so Article 47 of the Indian Constitution, which levels a duty, which says that it would be the duty of the state to raise the level of nutrition and standard of living and to improve public health. So the Constitution of India, through this provision of Article 47, guarantees that the state to provide, so they has to provide clean drinking water. The state, it's a duty of the state to provide clean drinking water and improve public health. And the constitutional jurisprudence of the country, which is developed by the judiciary, has placed drinking water as a derivative right within, by enhancing the purview of right to life under Article 21. And the reason because why it gets all the more complicated is that the whole concept, the water being a sub state matter, state subject, the parliament can exercise the power to legislate on water only under Article 249 and Article 252 of the Constitution of India. And hence the parliament has exercised its power under Article 252 and passed a law, an act, enacted the act, Water Prevention and Control of Pollution Act in 1974. And the Water Act represents the one of the India's first attempts to deal with an environmental issue in a comprehensive manner. And this act got amended in 1978 and in 1988 in order to conform to the provisions of the Environmental Protection Act of 1986. And if we talk about the act, this act was passed with the following objectives: to provide for the prevention and control of water pollution and maintaining, restoring the whole of wholesomeness of water in streams or well or sewer or land, to establish central and state boards for the prevention and control of water pollution, and to confer conferring on and assigning to such boards powers and functions relating thereto for matters connected therewith. So we to give such powers to these boards so they can carry out the functions which is given to them by this act under Water Prevention and Control of Pollution Act of 1974. Now, when we look at Section 2 of the Act, it deals with the definitions. Now, we are going to deal with certain, specific important definitions, but you must go through all of them. So, the Act defines pollution. So, Section 2, subclause E defines pollution as, such contaminations of water or such alterations of the physical, chemical, or biological properties of water, or such discharge of any sewage or trade effluent or any other liquid, gaseous, or solid substance into water, whether directly or indirectly, as may be or is likely to create a nuisance or render such water harmful or injurious to public health, safety, or to domestic, commercial, industrial, agricultural, or other legitimate uses, or to the life and health of animals or plants or plants or aquatic organisms. Okay, now then we'll look at the definition of sewage effluent, which is given under Section 2, Clause G. It talks about that states that the effluent from any sewage system or sewerage disposal works include sewage or from open drain. It talks about it, involves all of this. So when we talk about the definition of trade effluent, it's given under Section 2 and Clause K, and it says that the trade effluent includes any liquid, gaseous, or solid substances which is discharged from any premises used for carrying on any industry operation or process or treatment and disposal system other than domestic sewage. So it consisted of everything which gets discharged from any premises used for carrying out industry operation, processes, treatment, disposal system, except for the domestic sewage. So whether the sewage is discharged in the liquid form, gaseous, or solid substances, all of it is covered under this definition. Now, in order to achieve this objective, the aims of the Water Act, the central government under Section 63 of the Act has enacted, certain rules like Water Prevention and Control of Pollution Rules of 1975, the Central Board for Prevention and Control of Water Pollution Procedure for Transaction of Business Rules of 1975, the Water Prevention and Control of Pollution Cess Act of 1977, the Water Prevention and Control of Pollution Cess Rules of 1978. All of this we shall discuss later also. So now let's first talk about the composition of the boards that the act talks about. So chapter 2 deals with the central and state boards for prevention and control of water pollution. So section 3 in here, it says that it talks about the constitution of central board. So it says that the central government shall, with the effect from the date, uh, being a date not later than 6 months of the commencement of the act, shall, in order to exercise the power conferred on the power conferred and to perform the function assigned to the board, shall establish the board, uh, you know uh, uh, and the board shall consist of the following members: a full-time chairman, being a person having special knowledge or practical experience in respect of matters relating to environmental protection, or a person having knowledge and experience in administering institution dealing with matters aforesaid, to be nominated by the central government, and such number of officials which not exceeding 5 to be again nominated by the central government to represent the government, and such number of persons not exceeding 5 to be nominated by the central government from amongst the members of the state board, of whom not exceeding 2 shall be from the referred, not less than 2 shall be from those referred in clause C of subsection 2 of section 4, and such a number of non-official members not exceeding 3 are to be nominated by the central government to represent the interest of agriculture, fishery or industry or trade or other interest which is in the opinion of the central government ought to be represented. 2 persons to represent the companies or corporation owned, controlled or managed by the central government are to be nominated by the government. A full-time member secretary possessing qualification, knowledge and experience of scientific, engineering or management aspects of pollution control to be appointed by the central government. Subsection 3 says that the central board shall be a body corporate with name aforesaid, having perpetual succession and a common seal with power, subject to provisions of this act, to acquire, hold and dispose of property, and to contract and may by the aforesaid name can sue or can be sued also. Now, if you look at the composition and the manner of appointment is as similar to the boards that we have already dealt with in air pollution and control of air prevention and control of pollution act of 1981. So section 4 it talks about constitution of state board, and it says that subsection 1 that the state government shall with effect from such date that it may notify by notification in the official gazette appoint or constitute a state pollution control board under such name as may be specified in the notification, so that these board can exercise the power, and so that the power can be conferred of them on them and they can perform their function which is assigned to them by the act. Subsection 2 says that the board shall consist of the following members. Again, a chairman being a person having special knowledge or practical experience in respect of matters relating to environmental protection, or a person having knowledge and experience in administering institutions dealing with the matters aforesaid, to be nominated by the state government. Now, provided that the chairman may be either whole time or part time as the state government may think fit. So it is up to the state government to decide whether the chairman tenure is to be full time or it is going to be part time. Now, clause B says that such number of officials not exceeding 5 to be nominated by the state government to represent the government. Then such number of persons not exceeding 5 to be nominated by the state government from amongst the members of the local authorities functioning within the state. Now, clause D says that such number of non-officials not exceeding 3 to be nominated by the state government to represent the interest of the agriculture, fishery, or industry or trade, or any other interest which, in the opinion of the state government, ought to be represented. Okay. Now, clause E says that 2 persons to represent the companies or corporations owned, controlled, or managed by the state government to be nominated by that state government only. Now, a full-time member secretary possessing qualification, knowledge, and experience of scientific, engineering, or management aspects of pollution control to be nominated by the state government. Now, if you look at subsection 3 of section 4, it says that again that the state board shall be a body corporate and with the name specified by the state government in the notification under subsection 1, having perpetual succession and a common seal with power, subject to this provision of the act, and can acquire, hold, dispose of property, can contract and may by the said name be sued or can sue also. Now, subsection 4 says that notwithstanding anything contained in this section, No state board shall be constituted for a union territory. So there has to be no state board in the union territory. And in relation to union territory, it would be the central board who shall exercise the powers and perform the functions of a state board in a union territory. And the proviso state that in relation to union territory, the central board may delegate all or any of its powers and function under this subsection to such body or body of person as the central government may specify. So central government may further delegate its duties, its functions to some body or any body of person, any person or any body of person to do its perform its duty in the union territory. Now if we look at now we will talk about which is something different in water act then when we compare it with the air act, that is this whole concept of joint boards, which is given under chapter 3 of water prevention and control of pollution act, and section 13 particularly deals with the concept of joint boards. It says that subsection 1 says, notwithstanding anything contained in this act, an agreement may be entered into. May be entered into. Okay, so again, it's not obligatory. Clause A says by two or more governments of contiguous states or by central government in respect of one or more union territories and one or more governments of state contiguous to such union territories or union territory or union territories to be in force for such period and to be subject to renewal for such further period, if any, as may be specified in the agreement to provide for the constitution of joint board. Okay, in a case referred to in clause A for all participating states, and in a case referred to in clause B for all participating union territories or union territories of the state or states. So now it's agreement can be formed between governments that they can have a common board. So that is how a joint board can come into existence. Now when you know that the union territories, their functions are to be performed by the central government, so there will be the central government, so the agreement will be formed between the central government and the states to constitute a joint board. Okay, now subsection 2 says an agreement under this section may clause A says that provide in a case referred to in clause A of subsection 1 for the apportionment between the participating states, and in a case referred to in clause B of that subsection, and for the apportionment between the central government and the participating state government or state governments of the expenditure in connection with the joint board. Clause B says determine in case referred to in clause A of subsection 1 which of participating state government, or in case referred to in clause B of that subsection whether the central government or the participating state, if there are more than one participating state also, which of the participating state governments shall exercise and perform several functions and functions of the state government under this act, and reference in this act to the state government shall be construed accordingly. So they can determine that participating states government can determine that whether the who is going to perform what kind of functions. So the central government or the participating state government, if there is more than one participating state of which participating state governments shall exercise and perform several powers functions of the state government under this act. And clause C says that they provide for consultation in a case referred to in clause A of subsection 1 between the participating governments, in a case referred to in clause B of that subsection between the central government and the participating state government or state governments, either generally or with reference to particular matters arising under this act. Clause D says such make such incidental and ancillary provisions not inconsistent with this act as may be deemed necessary or expedient of giving effect to the agreement. So for the purpose of fulfilling the objective of the act, they can also create or make such ancillary provisions also. Such provisions which are not inconsistent with the act itself. in order to give effect to the agreement that they have created. Now subsection 3 says an agreement under this section shall be published in a case referred to in clause A of subsection 1 in the official gazette of the participating state, in a case referred to in clause B of that subsection in the official gazette of the participating union territories or union territories and participating state or states. So they have to, if there is an agreement between a state and union territory, so it has to be notification, it has to be notified in the official gazette of the same. And if the agreement is between the two, between states, then it has to be notified about the such agreement, has to be published in the official gazette of the participating state. Now next, we will look into the the composition of joint boards. So that is given under section 14. Section 14 here, it talks about the subsection 1 says a joint board constituted in pursuance of an agreement entered into under clause A of subsection 1 of section 13 shall consist of following members: a full-time chairman, being a person again having special knowledge or practical experience in respect of matters relating to environmental protection, or a person having knowledge and experience in administering institutions dealing with matters aforesaid to be nominated by the central government. Okay, and two officials from each of the participating states to be nominated by the concerned participating state government to represent that government. And clause C says one person to be nominated by each of the participating governments from amongst the members of the local authority functioning within the state concerned. Now, clause D says that one non official to be nominated by each of the participating state government to represent the interest of the agriculture, fishery, industry or trade in the state concerned, or any other interest in which interest which in the opinion of the participating states requires representation. Now two-person to be nominated by the central government to represent the companies corporation owned, controlled or managed by the participating state government. Clause F says that a full time member secretary possessing qualification, knowledge, and experience of scientific, engineering, or management aspects of pollution control to be nominated by the central government. Now, subsection 2 of section 14 says a joint board constituted in pursuance of an agreement entered in under clause B of subsection 1 of section 13 shall be shall consist of the following members. It shall consist. So what exactly is subsection 1 and section 13? When there is a agreement to form a joint board between state and UT, so such joint board shall have clause A says a full-time chairman being a person having special knowledge or practical experience in respect of matters relating to environmental protection, or a person having knowledge and experience in administering institution dealing with matters aforesaid to be nominated by the central government. Clause B says two officials to be nominated by the central government from the participating union territory or each of the participating union territory as the case may be, and two officials to be nominated from the participating state or each of the participating state as the case may be by the concerned participating state. Clause C says one person to be nominated by the central government from amongst the members of the local authority functioning within the particular union territory or each of the participating union territory as the case may be, and one person to be nominated from amongst the member of the local authorities functioning within the participating state or each of the participating state as the case may be by the concerned participating state government. Okay, now one clause D says one non-official to be nominated by central government and one person to be nominated by participating state government. So central government, if they are nominating, means it will be for representing that particular UT. Okay. Or state government to represent the interest of agriculture, fishery, industry, trade in the UT, or in each of the union territories, or the state in each of the states, as the case may be, or any other interest which is in the opinion of the central government, or as the case may be, of the state government is to be represented. Clause E says two-person to be nominated by the central government to represent the companies or corporation owned, controlled or managed by the central government and situate in the participating union territory or territories, and two-person to be nominated by central government to represent the companies corporation owned, controlled and managed by the participating state. Now clause F finally again is the similarity. A full-time member secretary possessing qualification, knowledge and experience of scientific, engineering and management aspects of pollution control to be nominated by again central government. Subsection 3 says when a joint board is constituted in pursuance of an agreement under clause B of subsection 1 of section 13 and the provisions of subsection 4 of section 4 of shall cease to apply in relation to UT for which the joint board is constituted. Now, subsection 4 says, subject to the provisions of subsection 3, the provision of subsection 3 of section 4 and section 5 to 12 inclusive shall apply in relation to the joint board and its member secretary as they apply in relation to a state board and its member secretary. Subsection 5 says any reference in the Act to the state board shall, unless the context otherwise requires, be construed as including a joint board. So whenever you have found, on the basis of an agreement, you have found a joint board, you have constituted a joint board. So whenever you are referring to a state board, it will be a joint board only. Okay. Now next we will deal with the power of delegation. So for which we'll talk about section 11A of Water Prevention and Control of Pollution Act of 1974. It says that the power of delegation of chairman. So it talks about the chairman of a board shall exercise such powers and perform such duties as may be prescribed or as may from time to time be delegated to him by the board. So the power of chairman, so chairman of a board shall exercise such power and perform such duties that has been given to him by time to time, from time to time by the pollution control board itself.